Good morning, Anne. What I'd like to talk to you about is commercial contracts. Our members enter into these contracts every single day, and normally they work absolutely fine, but just occasionally things go disastrously wrong. So it'd be useful to understand the basic underpinnings of commercial contracts.
Yes, and first off, one of the myths about contracts is that they've got to be signed and they've got to be written. Actually, you can quite easily enter into a verbal contract. The problem arises when you try and enforce that because you've got no evidence as to what it was that you were agreeing to.
Right, so it doesn't need to be written down. Are there other elements that one needs to identify to see whether a contract has been entered into?
A court, if it comes to a court, will look at four things. Has there been an offer?
Mm-hmm.
Has there been acceptance of that offer? Has there been consideration given both ways? So that's money or money's worth. And although not particularly important in business-to-business contracts, was there an intention to create legal relations?
Right, okay. So let's take that from the top. The first element was an offer. What constitutes an offer?
Well, there's a lot of wonderful Victorian case law about contracts and about what's an offer and how it's accepted, etc. Normally it's fairly obvious, but for instance, if you go to a supermarket and there are product on the shelf with prices displayed, that's not an offer to sell you at that price. That's what's called an invitation to treat. So if you take that into our own context in the print industry, if you've got a price list that you've sent out to somebody, that price list is not an offer to sell or to do the work at that price. It's merely what's called an invitation to treat, which is sort of like a pre-offer.
So you talked about an offer. The second element here is acceptance. Could you tell me a little bit more about what constitutes acceptance?
Yes, and it can often fall over at this stage because you've offered to do the work for me at a certain price. I come back to you saying, well, that sounds okay, let's go for it, but, and then I put some qualifications in place. So I haven't really accepted your offer, I've qualified it. And so the question is, when is an acceptance clear and unequivocal?
Okay, that sounds potentially quite complicated. And then the third element was consideration.
Yes, and that has to go both ways. So if I am the customer, then I'm going to be paying you. So that's my consideration to you. Your consideration to me is doing the job. So it's performance of the job. And that can become an issue if, for instance, we're a long-term customer and we have a long-term customer relationship. And I say to you, just can you do the job in the usual way? And you produce it, but on a different sort of paper. And I might say, well, that's not what I've asked for. You have not provided proper consideration, and I don't have to pay for it.
Okay, so there's those three elements: there's offer, acceptance, consideration, and then the final element is the intention to create legal relations, which sounds intriguing.
I know, and it usually doesn't really apply in business contracts. But
right.
For instance, if I said to my husband, "I'll do the cooking if you'll do the washing up," and he says, "Okay, that's fine." There is no intention to create legal relations there, clearly.
Okay. That sounds fairly straightforward. So, assuming those four elements are all in place, there's a contract there. It may not be written down. What should go into a standard contract?
Well, of course, if you've got a very complicated and specific type of product that you're developing for this customer, you may want a very, very bespoke contract. But there are absolutely standard terms that go into every contract pretty much, which are going to be about the time scale for the delivery, how it's going to be delivered and when, who's going to be liable for things going wrong. And obviously as the producer you're going to try and limit your liability, as the customer I'm going to try and load it all onto you. Fitness for purpose, quality, anything, many other terms and conditions will go into your contract. Those terms may also be implied by statute. So you remember at the beginning I said nothing had to be written down. Even if it is written down, you can find things like the Sale of Goods and Services Act are implying things into your contract which aren't otherwise in there, or even just custom and practice. If we've always contracted in a certain way, then it's likely that if it came to an argument, the court would look at how it had been done before and imply those terms into the contract.
Okay, you mentioned the court there. I mean, are there things that a court will look for in particular over and above what you've already mentioned?
Yes, it will look at the contract in the round.
Yeah.
And that might be bits of back of the envelope, might be bits of email, can also be what salespeople have promised out in the field beforehand, if that hasn't been excluded in your contract. It will look at who the parties are to the contract, and that is often a problem in our industry, that because everybody's very busy. You don't have time to do all these sort of checks. But actually, who are you contracting with? Is it a limited company? Is it Joe Bloggs? Is he trading as something? Because if you haven't got a contract with the right entity, you're not going to be able to enforce a payment of your invoice at the end of it. So it's important to make sure the parties are clear. And most important of all is the court will look at was there a meeting of the minds between the two parties, and that's for the court to decide. Is there enough evidence to show that this is what was meant to be contracted?
I mean, there's a lot of variables there. There are, in our industry, a lot of people out talk to customers all the time. They may create a contractual situation, or they may not actually. Are there things that member companies can be doing to avoid the pitfalls?
Certainly, have a standard process, particularly when you're taking on a new customer, to induct them into your standard terms and conditions. Make sure you have standard terms and conditions. Make sure any spec that you give is detailed enough. Proofs, make sure that if you're going to ask your customer to read proofs, make sure they've read them and signed them off. And as I've said before, make sure you've correctly identified the customer, particularly if it's a new customer. Make sure you know who it is you're supposed to be dealing with.
There's been a situation with standard forms where there's been a debate about whose terms apply, the so-called battle of the forms. The
battle of the forms, yes. This comes about where I send you a quote for a job with my terms and conditions on the back. Yeah. You send me back a purchase order, which would appear to be an acceptance, but it's got your terms and conditions on the back, which are different to my terms and conditions. The battle of the forms is, okay, then whose terms and conditions apply? Usually it's the last terms and conditions before performance of the contract. So in this case, it would be your purchase order terms rather than my terms. It used to be, and I hope that it's beginning to die out, that members used to think that putting their terms and conditions on their invoices as the first time that they're mentioned was sufficient. But of course, by the time you're invoicing somebody, the contract's been done and dusted, and you can't be discussing terms at that stage.
So an important thing is to establish the terms and conditions before really the work is committed to, and avoid problems further down the line. And it potentially makes it sound as if business might grind to a halt if that process carries on forever. But I guess common sense ultimately applies, and business must carry on.
And any lawyer will agree that although this is a legalistic view of it, normally in business you want to maintain the goodwill of your customer, and so you're going to sort it out one way or another. However, if at least you've got the basics in place, then if there's a falling out and you need to go to the court, you've got the basics in place, and a lawyer is going to be able to assist you in your case.
I think things normally are absolutely fine, but just now and then they do go wrong. We all know that. That's the industry that we're in, and I think the point that's important here seems to me to be about being as clear as possible about whose terms apply when one goes into that discussion, to try and resolve problems, which we normally all do without recourse to the courts. But it is very much a last resort. Thank you very much, Anne.